So hello and welcome to the first webinar in the Kent Law School Summer of Law free webinar programme of 2020. This programme of webinars offers a really exciting opportunity, especially for those of you who are thinking of coming to university to study law, or indeed holding a place to come and study with us, to gain a taste of the subjects that you're going to be studying on a law degree and start to think about the skills that you'll need to develop for successful study. And if you're watching this webinar simply because what we do here at Kent Law School without necessarily any plans to come and study, well, welcome to you too. Glad to have you here. So this first session is looking at criminal prosecutions. And if you've had a look at the list of upcoming sessions, you'll see that we have a mixture of subjects. So we have a session on property law, for example, public law, international law, plus we have sessions that are more skills-based. So how to read the law, statutes and case law, how to build a legal argument, and so on. So a really interesting programme of events coming up. My name is Laura Charleton and I'm a lecturer at Kent Law School. Previously, I was a barrister. I was in a common law set, which means that I represented clients across a range of legal disputes in different areas of law, family law, contract law, the law of negligence. But my main area of specialism was criminal law. And so I undertook prosecutions on behalf of the Crown Prosecution Service. And I also represented defendants who have been charged with offences. So as an independent barrister, I worked for both sides of the adversarial system, if you like, prosecution and defence. My academic interests lie in the role of the victim in the criminal trial, and you'll find me lecturing on various modules at Kent Law School. I'm also joined today by my colleague, virtually joined, Dr. Mo Afshary. Mo, introduce yourself.
Hello, everybody. Fantastic to be here today. As Laura said, my name is Mo Afshary. I am a member of staff at Kent Law School. You will mostly see me, if you're here next year, in teaching criminal law. I also teach some public law lectures as well. That's in terms of teaching. In terms of research, the main area of my research consists in working with criminal defense lawyers in terms of how they work with their clients, the sort of ethical, social aspects of the work, and so on. So I'll stop there.
Thanks, Mo. So there's three main reasons why we thought we would talk about criminal prosecutions today. Firstly, because if you do come to the university to study law, you will study criminal law, whether you study with us or elsewhere in England and Wales, because it is one of those 7 foundations of legal knowledge which need to be studied effectively in order to go on to qualify as a solicitor or a barrister. Not that everyone law graduates go on to careers using their law degree, but not as lawyers. So it's a compulsory module, criminal law. We also study English legal system, of which of course criminal prosecutions is a part. There are other optional modules that relate to criminal, for example, to study policing module, and also the law of evidence at Kent Law School. Plus we have a fantastic co-curricular programme of modules that you can choose to study whilst you're with us, and one of those is the mock trial advocacy module, which is effectively based in undertake the advocacy of the prosecution and the defence inside our own moot court. So that's one reason why we're looking at criminal prosecutions today. Also, second reason, because prosecutions and indeed the criminal law, like so many aspects of our lives at the moment, have been very largely impacted by the coronavirus global pandemic. And it's interesting to keep up to date and informed about that impact and how the criminal justice system is dealing with it, particularly when you consider that the criminal justice system is dealing with people's liberty. The third reason why we're looking at criminal prosecutions is because you may find yourself entangled in the criminal justice system, either as a complainant, a witness, the accused, the relative of any of the above, and more than that, in a more sort of subtle way, but equally important way, our lives are impacted by criminal law, perhaps without us knowing or thinking about it. So it sort of dictates how we behave and sets the boundaries of what is deemed to be acceptable behaviour, unacceptable behaviour. We can lose our liberty if we cross those boundaries. But what's interesting to think about is who decides what behaviour is criminalised, and on what basis is that decision made, and what role do lawyers play in all of this. There's more to criminal law than perhaps is portrayed on the television and in the movies. And so today we hope to get you thinking about criminal law, criminal prosecutions, the role of the lawyer, possibly leaving you with more answers than, possibly leaving you with more questions than answers. Which is fine, because you need an inquiring mind. It's not really about knowing things, it's more about inquiring into why things are that makes you a successful critical student of the law. Sorry, I'm not sure if my audio broke up a little bit during that, but hopefully you could hear me. So the plan for today, talking to you about criminal prosecutions, thinking about how and why some conduct is criminalised, and then we'll move on to think about the criminal justice system, so who is involved in that system, what happens in a sort of typical case, and who makes decisions to prosecute. And then Mo will talk about how the criminal justice system operates in practice, using a kind of topical example. And then it's your opportunity to join in by thinking about some scenarios and their likely outcomes. We'd love to join in if you're watching us live. So Mo will explain how to do that later. No pressure, but we'd love you to participate. And if you're watching this as a recording, incidentally, you can still think about the different scenarios and then see how the audience today responded and what we thought about that. Then Mo will talk about how we take a critical approach to the study of law at Kent Law School and why that's so important to be a critical lawyer. And then to conclude, I'll highlight sort of three main takeaway points from the session and point you in the direction of some further resources that you might want to look at in the meantime. Now, clearly, I've just described a huge amount of material, and we don't have very long together today. So today is really about highlighting, signposting the main themes, the concepts, the ideas. The issues are much more complex than we can sort of convey today. To sort of give an exhaustive analysis today, but hopefully it introduces you to some of the concepts and the approach that we take to studying law. Okay, so for this part of the session, I'm going to share some slides with you. So let's just get those up on the screen. There we go. And actually, if you haven't been to the Canterbury campus, the photograph here on this slide is the outside of the Wigader building on the Canterbury campus. And this houses our moot court. And it also houses the Kent Law Clinic. There's another shot of the building. And the next webinar, which is on the 4th of June, How to Learn from Law in Action, is hosted by a Kent Law Clinic, the Kent Law Clinic director and some of the solicitors at the clinic. And this is an opportunity for students to actually get involved in real life problems, cases that people have. And so they'll be talking about their experiences of how we can learn from real life cases. Really fascinating, great opportunity. So I'm going to spend a few minutes thinking about how and why we criminalise certain conduct and not other conduct. I suppose if I asked you what is a crime, then you'd no doubt be able to give me lots of examples of crimes. People often start with the most serious. They think of murder, there's theft, sexual assaults and so on. But how do we know that these are crimes? And although they cover such kind of different behaviours, what features do they have in common to make them criminal offences? Well, there is no sort of universal definition I can give you as to what is a crime, and indeed it will vary between jurisdictions. So perhaps some of you are watching today from other countries. What is considered a crime in England and Wales may differ considerably from what is considered a crime where you are now. But typically, how we differentiate criminal behaviour from non-criminal behaviour is through the attitude that the state adopts to that behaviour, because crimes can typically be described as acts, so someone's actions, and sometimes, although less so, through omissions by failing to do something, but generally actions that are punished by the law. So if you do something that contravenes a criminal offence, then you could be fined or made the subject of a community order. You could be sent to prison indeed. There's punishment, which is a kind of unique feature compared to other areas of law, where there may be, of course, ramifications for contravening the law. You may end up paying someone damages, for example, or compensation, but that's not a punishment, it's not punitive. In crime it is. So that raises the question, why are some acts then considered crimes when others aren't? And the second question, who gets to decide what is criminal and what isn't? So thinking first of all about why some behaviour is criminalised when other behaviour isn't, again, there's no straightforward answer here. I've put some suggestions on this slide as to, certain theories, schools of thought as to why some behaviour is deemed to be criminal, unacceptable, and why other behaviour isn't. Mo, do you want to give us an example perhaps of the rationale behind criminalising certain behaviour?
Yeah, it's an interesting aspect of criminal law in general in any country, because all of our social values come into play when we decide, or our governments decide, what should be criminalised, what should be punishable by the force of law, usually imprisonment, fines, and so on. I think I can give you an interesting, maybe relevant example in relation to sort of our circumstances these days. One act of parliament that was passed in 2018 was the Assaults on Emergency Workers Offence Act, which essentially increased the punishment for people who committed some kind of assault or battery against emergency workers, such as police officers, fire and rescue services staff, NHS staff like nurses and paramedics and so on. And we can see how this particular act of parliament speaks to some of our social values, because at the end of the day, especially these days, we can see that police, nurses, and so on, they are crucial for us to all stay safe and stay alive. And so for us as a society, I suppose, it makes a lot of sense to make sure to provide some kind of extra protection for those emergency workers.
Yeah, thanks, Mo. And I put a couple of pictures on the slide to sort of illustrate some thoughts on why conduct is criminalised, specific conduct. So, for example, the top picture there is a newsreader who just recently, when presenting the news, I don't know if you can see on the slide there, she has a phone number on her hand. That's a phone number for a domestic abuse helpline. The concern, of course, during this time of lockdown, that those who are being subjected to abuse at home, it's harder to seek help. And not long ago, the criminal law sort of finally recognised a gap in the need to be able to criminalise controlling and coercive behaviour, which isn't necessarily behaviour that was caught by other criminal offences, violent offences, because it isn't necessarily violent behaviour. And at the bottom there, we see, you know, a fine line between, you know, where do you draw the line between conduct that is acceptable and not acceptable? So, for example, you know, we have a right to protest, to express our views, but where do we draw the line between that and then going against public order and creating public disorder? And similarly with policing tactics, and of course we have seen some demonstrations already about, you know, the government measures about coronavirus, for example, and policing measures. You know, it's a fine line between the need to have powers to control and the rights of individuals to express their opinions. And so we see that sometimes we have different interests pulling in different directions when we're thinking about criminalising conduct. How conduct is criminalised then? Well, there's two main ways that we have crimes created. The first is through legislation, and the second is through the common law. So legislation is something that that comes from Parliament. So I've put a picture there of recent sitting in the House of Commons. So the House of Commons combined with the House of Lords legislate in Acts of Parliament, also referred to as statutes. And that's the end result, which then receives royal assent from the monarch, is a written document that will contain various crimes and the punishment attached to those crimes. Acts of Parliament also delegate power to others to make law without going through the same rigorous process that an Act of Parliament has gone through, because it's debated in both houses, there's votes, there's a certain amount of scrutiny. And so delegated legislation, a statutory instrument, would be an example of that. So that would be where I would suppose the bulk of our criminal offences are created in legislation. As an alternative, we have the common law being judge-made law, made in the courts. And when I talk about the courts here, I mean our highest courts. So not all of our courts have the power to make law. They apply the law to the situations in front of them. But our higher courts, so the High Court, the Court of Appeal, and then the Supreme Court, they do have the ability to make law where Parliament has not done so. So they sort of have a dual function, because on the one hand, they are interpreting the law that Parliament has created and applying it to the real life situations. And on the other, it's possible for them to make law also. Mo, do you want to give us some examples of that?
Yes. So again, what I would like to do is to make some references to something that is rather more relevant to us these days. In terms of the law, or rather criminal law or criminal offences that have been created by Parliament or by government, I think probably the most relevant pieces currently are, as you can see on the screen, the Coronavirus Act 2020, which was passed in March this year, just over 2 months ago. And I don't know if you were following the developments, and the rationale behind that Act of Parliament was to give power to the police and other sort of relevant persons to sometimes to basically direct or instruct somebody who is a potentially infectious person, direct them to hospitals or other sort of screening places, making sure that if somebody is a potentially infectious person, is taken to these screening centers and tested. Another very crucial piece of regulation that was passed recently, as you can see on the screen, and this only relates to England, is the Health Protection Coronavirus Restrictions Regulation 2020. The purpose of this particular regulation was to regulate how we were going to carry out the lockdown, in terms of basically the act or the regulation saying that nobody should leave their homes without reasonable excuse until further notice. There were obviously few exceptions. I'm sure you're all very familiar with those exceptions: taking daily exercise, shopping for essential items, or going to work if you're a key or emergency worker, and so on. But this particular act, this particular regulation gave power again to a number of public bodies, such as the police forces, to make sure people follow those new regulations. For instance, if the police had reasonable belief that somebody was outside in contravention of those regulations, they had the power to return them to their home, sometimes even by use of force if necessary. And they have power to fine them on the spot, and if it's a serious breach, they could also prosecute, basically send them to court for criminal prosecution. That's some examples of sort of acts of parliament and regulations. But as Laura mentioned already, there are a number of other criminal offences which are not specifically created by law or by parliament. They have been developed by judges through our common law system, which has been sort of essentially based on judges' decisions and the precedents they set. I make reference to a number of these common law offences. For instance, the first and the most important, the most serious offence, criminal offence, obviously, is murder, which is a common law offence. The way we understand murder today is very much based on several centuries of how the courts interpreted and basically enforced the idea of what is murder. Another set of criminal offences which are also relevant to our discussion today, I think, are assault and battery, which I will talk about later. But the essential idea here is that when a person inflicts unlawful force to another person, that is considered as battery. And of course, as I said, I will talk about them a little bit more later when we're talking about specific examples.
So here's a kind of diagram to show you the shape of the criminal justice system. So we've been talking about what might be criminalised and who makes the conduct criminal. Here is the system that deals with the criminal offences, and there's a few things I just want to sort of draw your attention to whilst looking at this diagram. So first of all, let's start with the victim for a second. Notice how the victim is very much pushed to the edge of this diagram, and in many ways that is reflective of the victim's experience of going through the criminal justice system. Because although the victim is, of course, for crimes with a victim, an essential component, they are pretty much dealt with as any other witness in the case. And so we have the victim there kind of on the side of the diagram. The offence itself in the kind of orangey box there. So that's the conduct that Parliament or the courts have sought to criminalise. And it will be said that someone committed an offence, so contravene that conduct. Either it's alleged that that's happened or it's clear that that has happened. And next we'll have the detection stage, where the police, we tend to think of the police in the criminal context, although there are a number of agencies that have the power to investigate and indeed prosecute. But here the police then will be identifying whether offences have been committed, and if so, you know, gathering the evidence, the pieces of evidence, in order to be able to prove that a case has been committed. The CPS, that's the Crown Prosecution Service. If I just skip ahead for a moment then, it's the Crown Prosecution Service who are the agency that will prosecute someone charged with an offence in court. And so they take the decision whether to prosecute that person. And the main test for deciding whether to prosecute someone, I've put on the screen here. So it's a two-stage test. I've put a link to the CPS, the Crown Prosecution Service website. Really invaluable source of information if you're interested in prosecuting and how decisions are taken. So the evidential stage, is there enough evidence here for what? Well, at this stage, to provide a realistic prospect of conviction. So the police will pass their file to the CPS, who will have a look and see, have we got enough evidence here for a realistic prospect of conviction? Which of course is a different test to what happens at court, because in a criminal case, the standard of proof is beyond reasonable doubt, or more commonly referred to as being sure. So we don't have such a high test at this stage, but is there a realistic prospect of conviction? And if there is, the second question for the Crown Prosecution Service to ask, is this prosecution in the public interest? So even if there is sufficient evidence, not every case will be prosecuted. The CPS, they're a public body, they're representing the public rather than the victim. They're representing all of us, and they're using our money to do so. And so here we see the CPS having to take sometimes difficult decisions. Mostly the public interest test is satisfied, but there are occasions where perhaps it's not in the public interest to prosecute. Having a look at this diagram then, we have the courts. So two courts mentioned on this diagram, the Magistrates Court and the Crown Court. These are the courts of first instance, the trial courts for criminal cases. And actually every criminal case will start in the Magistrates Court, and probably something like 95% will actually finish there. So it's really the kind of workhorse of the court system for criminal cases. And yet our attention tends to be drawn to the Crown Court cases, which have the more serious offences dealt with. So each offence is given a category, and some offences, summary only, have to stay in the Magistrates Court. Some indictable only, the most serious offences, have to be transferred to the Crown Court, and the rest are called either way offences. They could be dealt with in either court. The Magistrates Court, of course, have sort of reduced sentencing powers. Talking of sentencing, across the top there then you have the possible sentence of going to prison. Across the bottom you have a sentencing in the community, probation, community sentences. And then if you follow the dotted line running right along the bottom of my diagram here, taking us right back to the offence, we have the recognition of reoffending, and that for many there will be a cyclical processing through this system, a kind of a looping effect of being dealt with and then reoffending and so on. And the last thing I want to draw your attention to here, two things. Look at how many different agencies are involved in this system. It's not just kind of one cohesive whole. There are a number of different departments, agencies who come together to form the criminal justice system. And also note, because it will be relevant to what Mo is talking to you about later, that although I say the Crown Prosecution Service decide whether to prosecute someone, that's not strictly correct, because the police have powers to deal with offenders on the spot in some situations, and we've seen this in the more recent legislation and the regulations about the measures taken in this current global pandemic, with fixed penalty notices, for example, effectively bypassing the Crown Prosecution Service. And indeed, for many of the summary only, the minor offences, the bulk of what is in our criminal justice system, we see that the police will also be making the decisions whether to charge. So I'm going to hand you over to Mo now to give us a topical example of how the criminal justice system operates in practice currently, and then you'll have the opportunity to join in with some scenarios.
Okay, thank you, Laura. So what I would like to do now is to think a little bit more about some relevant examples of, again, our current circumstances. As I mentioned earlier, obviously, as a result of the the pandemic that we're under at the moment, the government and the parliament have had to introduce a number of provisions to make sure that everyone's safe. Obviously, there are police officers on the streets, making sure that people follow and do not contravene those new laws and regulations. However, one of the interesting things, if very disturbing developments that we have witnessed in the last few months since the introduction of these new laws in relation to the lockdown, is a number of people who have been arrested, or when the police were trying to arrest someone, or when nurses were trying to test somebody in hospitals. A number of people have rather reacted in extremely unpleasant ways, for instance, by spitting or coughing at those police officers and nurses and other key emergency workers who were trying to enforce the law. Now, the question I want to ask, or what I would like to talk about for another few minutes with you is, well, what can criminal law do when people do that? Is there any way, have there been any provisions in criminal law to allow and to help the criminal justice system to address these problems? In fact, we are seeing increasingly alarming number of people doing that. A number of, for instance, I remember reading somewhere a couple of weeks ago that one of the police forces across the country were reporting that something close to 30 officers every day were being spat at or coughed at by people who were being arrested or directed to go home and so on. Question is, what can criminal law do? Are there any ways to address this behavior, basically? Because obviously, especially in these circumstances, if you are infected by the virus, it would be extremely dangerous to obviously to infect somebody else. And when people do that, that would directly affect the way the police are able to, or effective in terms of carrying out their duties, whether nurses, other emergency workers are able to carry out their duties. So we do want to stop that. Now, let's show you the next slide, where I will look at some of these offences which could potentially be used by the Crown Prosecution Services to address these problems. One of the very old offences in the book is the offence of battery, subject to Section 39 of the Criminal Justice Act, 1988. In very simple terms, battery, as you can see on the screen, is when somebody inflicts unlawful force on another person, either intentionally or recklessly. Now, for battery, obviously, you need to have some use of force, and certainly you need some contact. This is one of the potential offences that Crown Prosecution Services have been considering in relation to charging those offenders. Some of you might want to ask the question that, but actually, wait a minute. If for battery you need the offender to actually touch or have some kind of contact with the victim, but how is a spitting contact? Because you're not really touching somebody by your hands or your feet or any part of your body. Well, you'll be pleased to know that as far as battery is concerned, there doesn't need to be direct contact. Something like, for instance, somebody in a pub drinking, if they throw their beer at somebody else, basically throwing liquid at somebody else, that is considered an example of battery. But the question is, that person must have intended to do so. So when somebody has intentionally, not accidentally, intentionally tried to spit at a police officer who is trying to arrest them, or at a nurse who is trying to test them, for instance, that can be considered as an example of battery. What's interesting now, of course, is actually spitting was always considered a battery. what's emerging today and these days under the coronavirus situation is that coughing is also becoming an example of battery, because it's essentially the same thing. Another particular offence that could be used by the Crown Prosecution Services to prosecute those people is what you see on the screen, the second offence, which is assaulting an emergency worker. This is basically, the idea is, as I mentioned earlier, the idea is to provide extra protection to our emergency workers, especially in times of emergency. What we don't want is our emergency workers being violated by people with very little protection. So that was the basic rationale behind this law. Now, in fact, the Crown Prosecution Services a few weeks ago, they made a statement addressed to those people who were intending to spit at police officers or cough at police officers and nurses and so on, that they will be using this particular piece of legislation to prosecute people who do try to inflict force on emergency workers. So it's an act of parliament that was passed in 2018, and it carries a maximum sentence of 12 months in usual circumstances. So that's another sort of potential charge that can be used. Now, the examples that I've mentioned already, what was missing is that all I talked about was people who basically spit at somebody else. How about examples where somebody who has been infected by the virus decides intentionally to infect somebody else by spitting at them? So their intention is not just to spit or sort of to stop them from being arrested, but is actually proactively trying to infect somebody else with the virus. If that is the case, we have another rather old offence of causing grievous bodily harm with intent, which is based on Section 18 of the Offences Against a Person Act. This is another Act of Parliament that you will be studying as part of, it's a major part of criminal law. Now, here the difference is, again, you're using force on somebody else, but the difference here is that you're intending to cause that victim serious bodily harm, really serious harm, or something that is often referred to as grievous bodily harm. Now, that's the most serious offence against a person, and it carries a maximum sentence of life imprisonment. Say, if you try to infect somebody with the coronavirus intentionally, that could be another avenue for the prosecution to take. So now, obviously, these are some of the some broad examples of what could happen and what the prosecution can do. What I would like to do also is sort of ask you some more questions in terms of some of the other potential scenarios that you could be faced as Crown Prosecution Services in such circumstances. In fact, what's interesting or rather disturbing is that there have been some very interesting ways people have been trying to use the spitting and coughing on police officers and emergency workers in very, very creative ways. So let me ask you some questions. So what I would like to do is to pose a number of hypothetical scenarios, and I would like to know what you think in terms of the answers. So I'll ask you a question. Now, what I would like you to do is to use the raise hand facilities on Zoom. I hope you know how to use the facilities to virtually raise your hand. So what I would then do is to see how many of you would agree or disagree with my question. So the first question I wanted to ask is, so I mentioned that if somebody spits at a police officer intentionally, that would be an example of battery. How about if somebody tries to walks towards a police officer, threatening to spit at them or cough at them, and they say, I have coronavirus, I'm going to infect you with the virus. Once they basically reach the face-to-face with the police officer, they don't do it. So threatening to do it, beginning to do it, but once they are there, they don't actually spit or cough at the police officer. My question is, should this be a criminal offence? When you threaten to do something, like to spit at a police officer, but you don't actually do it. So if you think this should be a criminal offence, raise your hand. Let's see how many of you raise your hands. If you think threatening to spit at a police officer should be an offence. Okay, quite a few people are suggesting that this should be an offence. Interesting. I think the majority, it's safe to say the majority think that this should be an offence. What I would like to do is to ask Laura to tell us, what do you think, Laura, should this be an offence? So what is the situation in terms of the criminal law?
So I agree with the majority, those of you who have raised your hands. This should be an offence, and it would be an offence. So Mo told you about the offence of battery, which is the infliction of force, but the other sort of common law offence that goes along with that is called common assault, somewhat confusingly because common assault sounds like it ought to involve physical force, but in fact it's putting someone, causing someone to apprehend, to fear force is going to be used against them imminently, and that really suits the scenario that you just described there, Mo. So it's intentionally, you know, meaning to do it, or recklessly causing someone else to fear immediate violence. And so you know, it could be raising a fist at somebody, waving a knife around, through your words, through your behaviour, causing that apprehension without needing any actual physical contact, any application of force. So that would be a common assault. It's a summary only offence, so it's dealt with in the magistrate's court, has a 6-month maximum penalty.
Thank you, Laura. So well done, majority of you who thought this was an offence. You were absolutely right. Let me ask you another question, slightly more tricky. So, and this is a real example, actually. This happened a few weeks ago, somewhere, I think, in Devon. So, despite all the lockdown conditions, somebody decided to throw a party, invited all their friends, something close to 30, 40 people were having a party in a house. Obviously, the concerned neighbors called the police and asked them to come and disperse the party. The police arrive, and they try to approach the house, and they try to basically tell the people, you need to leave, and so on and so forth, under the new regulations, under the coronavirus lockdown. What happened there was a number of people who were drunk, obviously this was a party, so that was okay. A number of people who were drunk started spitting at the police officer, basically trying to stop the police officers from carrying out their duties, arresting them or directing them to go back home. And the question is, what if somebody spits at a police officer or a nurse while drunk, while intoxicated by drugs or by alcohol? Should the fact that they're drunk, should that be some kind of a mitigating factor? Can we say that, well, because they were drunk, they didn't know what they were doing as such, so they should be let go? So what I would like to ask is, if you think spitting at a police officer while drunk, when you've voluntarily intoxicated, if you think this should still be an offence, do please raise your hands and let's see what you think.
A quick response there, Mo, from most people.
Very quick response. And again, we have a vast majority of people who think this should be a criminal offence. What do you think, Laura?
Well, I agree with the audience again, because intoxication, as you will find out when you study, if you come to study criminal law, it can be a defence in certain situations. But for this type of offence, where you can commit this offence either with intention or recklessly, so, oh, I can see some excellent comments in the comment panel there. So if you can commit an offence recklessly, intoxication is no defence, because it's reckless to get so drunk to commit such an offence. And so you do not benefit from any sort of defence of being intoxicated. So our audience were absolutely right, Mo.
Very well done. I think we're doing really, really well. Let me ask one more question if we have time, because I'm really getting warmed up. So let me ask you one last question. So again, we're in the same situation, same scenario. Let's imagine that this time somebody who actually has been infected with the virus, somebody who has the virus, decides that, you know, I'm very upset that the police are not letting me go out. They're not letting me to go to the park and play with my friends and family, whatever. And what I'm going to do, I'm going to teach this police officer or this nurse a lesson. I'm going to go and actively approach them and spit or cough at their face so that they catch it, so that will teach them a lesson. And you'd be surprised to hear people have been doing and thinking that. If that happens and somebody does that intentionally, question is, obviously, as we know, this would be an offence. But the question is, what if that police officer or that nurse sadly lose their life? In fact, some of you might know that a few weeks ago, this exact scenario took place somewhere in London. Somebody working in a ticket office in a train station was spat at by somebody who was infected by the virus, and as a result, allegedly they lost, well, it seems that they lost their life as a result of infection that was basically transmitted to them by that person. Now, that was a very disturbing case, of course, and of course, that particular case, we don't know all the facts, so I'm not necessarily asking you about that particular case, but in general, if somebody causes another person to die by spitting at them, should this be I mean, what can we do? Should this be considered murder? If you think this should be murder, or yeah, so if you think this should be an offence of murder, if this person should be charged with murder, do please raise your hands. Okay. Again, we have a fair majority. I feel like opinions are a bit more divided on this one, it looks like. Quite a number of people think this should not be murder, which is the most serious offence. Let's see what Laura thinks.
Yeah, I'm just looking at some of the comments, Mo. People are raising some really good points. I mean, okay, there's a lot of what ifs and so on. I'll just be a lawyer and couch my answer with with some sort of back up there. But effectively then, if they intentionally spat at the person, for example, knowing they have coronavirus, wanting to infect that person with coronavirus, and that person did not pass away, we would probably be looking at a Section 18 offence that you told us about earlier, because it's the intentional infliction of serious harm, grievous bodily harm, serious harm. That person sadly dying as a result, and that's important few words, as a result, because the offence of murder is a result crime. You need to show causation, that it was the defendant's actions that caused the death. But if that could be shown, and the intention was to cause serious harm to the victim, then that would satisfy the mens rea for the offence of murder, because the mental element required, the mens rea, is an intention to kill or an intention to cause grievous bodily harm, serious harm. However, if the intention were not to be able to be proven, or the intention wasn't there, then we could perhaps look at manslaughter as an alternative, a lesser offence. So we have different types of manslaughter. Unlawful act manslaughter would be one example, where the defendant has done an unlawful and a dangerous act, the spitting, and that has resulted in someone's death. I wish we had time to answer all the questions that are popping up, I can see, because they're all really good questions, but sadly time is against us today. But it's so exciting to see everyone thinking about these things and thinking critically about what we're saying. That is exactly the kind of characteristics of someone who will be a successful lawyer and law student, I would say.
Okay, thank you, Laura. I had a few more questions, but unfortunately, that'll be for another day and another time. Now, so we did talk about some of the new laws and regulations that were put in place during the coronavirus, some of the new powers that were given to the police and a number of other emergency workers to enforce the law. And obviously, for many of us, for most of us, many of our freedoms have been taken away. We are no longer able to just do a lot of things we used to be able to do easily. And obviously, a lot of our rights and freedoms have been at least restricted, if not completely taken away. Now, what I want to sort of finish this section of our session is to reflect a little bit more on the sort of approach to take to studying law. Specifically, there is a long tradition of what we call critical legal studies that we have been doing at Kent. In fact, Kent Law School is one of very few law centres, law schools in this country who actively and proactively rather emphasise for students to take and adopt a critical approach to their legal education. Now, what I would like to do is to say a few words to kind of sum up what we've been saying in terms of what would a critical approach to coronavirus laws mean for us as lawyers, law students, and so on. So I've put something on the slide for you. Again, very brief comments I'm going to make. Obviously, we are running out of time. One of the major issues with criminal law, as with many other areas of law, is how to strike a balance between state power, protecting public interest, and protecting individuals' rights and freedoms. On the one hand, obviously, we want the police officers to have power to enforce Coronavirus Act. We want them to be tough on those people who are violating the laws because they are putting all of us in danger. I think there's no question there. We want the police to protect the public. At the same time, a critical lawyer, a critical law student, a critical approach to law would always question where the line is in terms of how do we strike between state power and public interest as against individual rights. Because with power comes responsibility. With powers certainly need to come accountability. We do want our police officers to do a lot of things that they weren't used to do, but we don't also want them to misuse those powers. We don't want to have our rights and freedoms taken away unnecessarily. So one of the interesting, if rather disturbing developments that we've had since the coronavirus laws came to force was there were a lot of confusion as to what powers the police have in terms of what kind of law enforcement powers do they have. What's interesting, for instance, you might be interested to know is for a very long time, the police thought they had the power to stop people on the streets and ask them where they were going, why they were at site, where they were headed, and so on. Turns out, yes, this was the advice by the government for the police to make sure that people do not go outside unnecessarily, but the law does not give the police power to do so. It took a number of lawyers to raise the point time and again, finally, for the police to realize that they were making a mistake. Or another interesting example is the basic rule of the coronavirus lockdown, which is social distancing for 2 meters. You might be interested to know that the 2 meter distance is not legally enforceable. Nowhere in the law it says people should be apart for 2 meters. This is basically an advice, a guideline given by the government, which is an advice. It's not legally enforceable. My point is, in times like these, in emergency times, emergency situations, it's very easy for the confusion that is caused to work against our individual rights and freedoms when the police become rather, sometimes a bit too proactive in enforcing powers they do not possess. A critical student, a critical lawyer, a critical education, in fact, always ask questions about who has power to do what. Is that justified? Another thing that critical lawyers and a critical education should always involve and include is understanding the law, not as what is in the books, but also what is as understanding the law, if you like, as a social phenomenon, something that takes place in society. I'm sure many of you would be able to go and read laws in all sorts of statute books, but how those laws are actually given effect in courts, on the streets, is sometimes a whole different matter. A critical lawyer, a critical student would always ask questions about how do our social values affect how laws are implemented and carried out. I wish I had more time to talk about this, but unfortunately we are running out of time. So I hand over to Laura to continue.
From us both today, we wanted to tell you 3 kind of takeaway points, 3 things to take away from today's session. I suppose the first is the significance of understanding why and how conduct is criminalised. It's not enough just to know offences exist and to be able to say what they are. That's the sort of black letter law, which is important, but understanding how they came into existence, maybe sometimes under pressure, reacting to situations, can help us to better understand why that conduct is criminalised or not criminalised, the rationale or the lack of rationale behind the criminal offences. Second, the significance in practice. Again, it's one thing to be able to describe the institutions, the different parts of the system, but understanding how they actually operate and the difficult decisions that are taken. I mean, you know, it was the nuances of the situations that Mo gave us to think about. It's not black and white, and the system, you know, by understanding how it operates, we can see its failings as well as what works. And the third point to take away is the importance of approaching this from a critical view, which Mo has just been demonstrating, questioning, challenging, thinking about power, the exercise of power, and by better understanding that, perhaps being able to affect change as well. Lastly, from us then, some resources that you might want to use to go to do some further research. I think both of us would say keep up to date with current affairs is probably the most important thing. But secondly, you may have seen the blog post, the Hello KLS blog post, which lists a number of different resources that you could go to, including the Secret Barrister blog, for example, if you're particularly looking for some, well, quite a bit of criticism about the criminal justice system. And on behalf of myself and Mo, and indeed everyone who's been involved in putting together these webinars, I want to thank you all for participating. We hope that it's been a useful insight into the criminal justice system, criminal prosecutions, and inspired you to keep up to date with what's going on and to question, to query, to inquire into why things are so and what the alternatives could be. So it's goodbye from both of us. Thank you for joining us today.
Thank you. Goodbye.